All right. Hi, everybody. I'm gonna get started here. Okay, there I am. So, hi, welcome. We are gonna get started here. I appreciate everybody coming out and hope you all have your lunches and all ready to get started. I'm going to, try to hide some of the other participants here. All right, so I'm Kate Gramlich and I'm from the Lawrence Public Library and just want to welcome you to the first installment of our Lunch and Learn About Death series. This Before You Check Out monthly series is a partnership between the library, LMH Health, Midland Care, and visiting nurses. And today's event will be focusing on your death to-do list, which would be things to consider when you're getting your affairs in order, no matter your age or stage in life. So just a little housekeeping, the program goes from noon until 1:30 and the last half hour or so would be open to Q&A. You'll see it's actually literally called Q&A feature that'll be at the bottom of your screen. So if you can use that as you're going to ask questions, we will get to those during the Q&A portion. So I'm excited to welcome our presenters. We've got Erin Yellen from the K-State Extension, and she's here to talk about healthcare directives. She has a PhD in family sciences and a graduate certificate in gerontology from the University of Kentucky. Through her work at the Extension, Erin promotes embracing aging, including health and wellness and advanced healthcare planning. We've also got Webb Golden from Stevens & Brand, who will be discussing financial and estate planning. Webb was previously named Lawyer of the Year by Best Lawyers in the practice area of trust and estates. He is a former associate professor and lecturer for the KU School of Law and has been active on many community boards. So welcome to our presenters, and just got my first question here. So before we get started, we are recording and we will be sharing out the recording on the library website. I think our other partners are going to be sharing it as well. So stay tuned for that. If you have folks who couldn't make it, we will have the recording available. So I will hand it over to Erin.
Great, thank you, Kate. And I am going to pull up my screen here and hopefully share it. Okay, can you see the full PowerPoint screen?
Yes.
Okay, perfect. So it's not the one where you can see that you're editing it?
Right, yeah, you're good.
Okay, perfect. It's a bit more difficult working from home with only one screen. And speaking of working from home, I do have 2 elementary age kiddos at home. So I've told them not to interrupt mommy, but they don't always listen. So if we have visitors, they'll say hello. So anyways, I am Dr. Erin Yellen from Kansas State University, and I've been doing some work on advanced healthcare planning in Kansas for several years now. When I first came to K-State, this was one of the first things that people around the state were asking me to do and update our materials on this, because there's so much interest in completing your advanced healthcare planning, and it's something that's incredibly important. So what are your advanced healthcare directives? And again, I will only be talking about the medical related ones, and then Webb will be talking about those financial ones. So in general, though, advanced directives are legal documents that allow you to voice your wishes regarding future medical care or treatment in the event that you become unable to do so for yourself. And the first thing that I want to point out with this is that it's not only for older adults, because as you know, anyone can get injured, have some sort of severe accident or medical crisis at any age. And so I always recommend that anyone over the age of 18 complete these documents. And it's also important to know that you can update them at any time. So between the time that you're 18 and 98, your opinions and wishes might change, and you can certainly update these at any time. So I'm going to go through 3 different documents today and explain what they are and also explain the ease of completing them and encourage you to get these done. The first document is the durable power of attorney for healthcare. And this is where you appoint someone called an agent to speak on your behalf. So essentially what an agent means is just a person that's going to speak on your behalf and help you to help make decisions on your behalf should you become incapacitated and no longer to speak for yourself. So just as I said, they will only speak for you only if you become incapacitated due to illness or injury. What kind of decisions can they make? They can make lots of decisions for you, such as how and who to treat you. So what types of medical procedures should be done and who should be doing them, and even where this should be done. So for example, in rural Kansas, many times there may not be specialty doctors available, or you may need more specialized care from a larger city or larger hospital. And this individual can make that decision and alongside the doctors, whether or not it's time to transfer you to a different facility. They can also make decisions regarding organ donation, whether or not you have an autopsy completed, and then what to do with your body after death. So they can make a whole lot of decisions for you. But it's important to know that they cannot revoke your written wishes from a living will. And we'll talk about a living will in a minute. So they can make a whole lot of decisions, but if you have your wishes in writing, they have to follow those. And essentially, they're a great person to make sure that your wishes are being followed. So the biggest question that I always get is, who should I appoint to be my durable power of attorney for healthcare? The first point that I always make is that it should be someone that you trust, even if this individual has opposing wishes. So for example, if they wish something else would happen if they were to become incapacitated than what you wish, they're still going to do what you believe and what your wishes are. They're going to carry out what you want, regardless of what their own beliefs are. So that is something that really comes back to trust. Do you trust that individual to make the wishes or the decisions that you want made on your behalf? You also want that person to be someone who knows you well. They know who you are, what type of person you are, sort of what your general life goals are, your general stances on death and dying, these sorts of things. So someone who knows you well, who will advocate for you, and again, who will honor your wishes. So this is a person who you need to trust, be close with, who you know will carry out your wishes. And oftentimes the decision can be pretty tough, especially if you have multiple adult children or multiple friends or close family members. So it can be a tough decision. One thing that I recommend is always having open and honest communication. So if you pick one of your children and not the others, talk to your kids about why you made that decision and why you think that's the best decision. For my great aunt and uncle, they have 4 kids, and they chose their daughter that's a nurse to be their durable power of attorney for healthcare. She's not the oldest child, but she has the medical experience to be able to speak to death and dying and any types of medical issues that they may encounter. So think about who you trust, as well as who might have the most experience or knowledge related to healthcare. So next we'll go on to living will. So the durable power of attorney for healthcare is where you're appointing someone to make decisions and speak for you on your behalf. But the living will is a document that acts as an instruction list to your doctor, your family, and friends that tells them what type of care you would like to receive at the end of your life. So If you complete the fill in the blank form that Kansas offers, and we'll talk about that in a little bit, if you complete the basic form, the living will is essentially a request to die naturally using only comfort measures. So this is the basic concept that you don't want to be put on a ventilator or life support. You don't want to receive artificial nutrition and hydration. You don't want to receive those things that are going to artificially prolong your life. This doesn't mean that the medical staff cannot give you morphine or things like that to keep you comfortable. That's completely different, and this only talks about those artificial life-sustaining procedures. A living will also only comes into play if you are deemed terminal, that there really is no chance of recovery, that you are brain dead, you have suffered a near fatal accident or trauma. So that's very important to remember, that this is not if you have a chance at survival. The last document that I will talk about is the pre-hospital DNR, and this is a do not resuscitate order. And this is something that many older adults might have in place. Someone who has a terminal illness, such as cancer or any other type of disease. I know my dad, for instance, has an autoimmune liver disease, and his health is rapidly declining, and he has a DNR. So a lot of people in different health circumstances will have a DNR. This is also for incredibly elderly or frail individuals. Oftentimes these individuals have a DNR. For example, before my grandpa passed, he had a DNR. He was 92 and he was at peace with his life and ready to go when it was his time. So this is a very important decision to make and not one that should be taken lightly. So what is a do not resuscitate order? As you might imagine, it's a written document of your desire to not have resuscitation attempted should you stop breathing or your heart stop beating. So if you were to stop breathing or your heart were to stop beating, they would not provide CPR or any life-saving measures in that case. And again, this is not an easy decision. This should not be taken lightly, because this means that if one of those two things were to happen, they are going to let you succumb to your illness or trauma. So this is typically only for individuals who are older. You can sign a DNR anytime, but it's really strongly advised that only people who are terminal, older, and incredibly frail sign these documents, because it is such a big decision. So how can you complete these documents? So we've talked about the durable power of attorney for healthcare. That's where you name someone to make decisions on your behalf. We've talked about the living will, which is where you outline what you would like your end of life wishes to be. And we've talked about the do not resuscitate order, which is that you don't want CPR should your heart stop beating or you stop breathing. All three of these documents are incredibly easy to complete in Kansas. This is not true for all states. And in Kansas, we have wonderful statutes that allow you to complete these documents easily and quickly. And it's really a great thing that Kansas has in place for us. So they are fill in the blank forms. These forms are incredibly generic. So the durable power of attorney for healthcare, that is plain and simple, where you're naming someone to make those decisions for you. And that's pretty simple and straightforward. The living will template that Kansas provides simply states that you don't want any of those life-sustaining procedures. If your wishes differ from that, you can work with a lawyer to make that document fit exactly what you want. However, if you agree with the documents that are fill in the blank forms, you can easily complete those. So for the most part, you will write your name and information in, check some boxes, and then the most important thing with the documents is to make sure that they have been signed and dated, and they will be witnessed as well. And those witnesses do need to assure that you are cognitively competent and that you are signing these forms with zero pressure. You're not under duress. You are not being manipulated into signing anything. All of those things, that's really what we want those witness signatures to help us avoid. Or if you do not get them signed by witnesses, you can get it notarized. But the main thing that we want to make sure is that those are legibly signed and dated, notarized, or signed by witnesses. Your DNR will also have to be signed by your attending physician or the physician that you see most often for your annual care. So making sure that those signatures are provided is very important. And again, I just want to reiterate how easy it is to complete these forms. They're not daunting, they're quite easily understood, and I strongly encourage you to review them. And of course, if you have any questions, you can always reach out to an attorney or lawyer. Something that we have provided from K-State Research and Extension is a publication that completely outlines what we've been talking about, but in some more depth. So why is advanced healthcare planning important? What do these forms look like? What are all of the things that I need to consider? And you don't need to, I have this link up here just to remind me to talk about it, but we can share the link with you. And I'm not sure, I don't think I can pop it into the chat. So I will be sure to share that link and we will get it sent out to you. Okay. So some final things that I want to talk about related to these documents, and this is really important. So the first thing is organ donation. I also get a lot of questions about this. Even though it's not directly in those forms, it is important to remember that your durable power of attorney can make decisions regarding organ donation. So you can speak with that individual about your wishes, but you can also set this up in advance. You can register online at donatelifekansas.com/join, or you can just go to donatelifekansas.com and find out more information about organ and tissue donation. Also at the DMV, when you renew your driver's license, they should be asking you if you would like to be an organ donor. The last time I renewed my driver's license, they did not ask me. So you should be watching that and see if they ask you about that. And that's a good place where you can express those wishes as well. And you can also fill out or call this number to request a form that will be mailed to you. So if you don't have access to a computer, if someone, obviously you all have access to a computer, but if someone in your family doesn't have access to a computer or something like that, or they're not able to get to the library right now, that's something that they can do to call and request that form. The last thing that I want to talk about is very, very important, and that's storing and sharing your documents. Because if you complete these documents and nobody knows they exist, then it's completely worthless. They basically don't exist at that point. So it's very important that you are storing these in appropriate places, but that you're sharing these documents with the necessary individuals as well, so that people know where they are, what your wishes are, and that they can be accessed if you were to be in an emergency health situation. So it's very important that you store them in your house. If you have chronic medical issues, if you're older, you can even store these documents on your refrigerator, somewhere where if EMTs were to come to your house, they can easily grab them. In your vehicle is also important. So if you were to get in an accident, for example, any place that you frequently visit for long periods of time. And what I mean by this is if you are lucky enough to have a lake house or a second home, you'll want copies there. But most commonly, we want to be thinking about if we visit relatives often, such as adult children or grandkids, things like that. Maybe if you stay with friends often to visit, you'll want to have copies there as well, or at least make sure that you bring them with you. Family and close friends, again, is very important, making sure that people know that these documents exist, that they have copies. With your physician and your hospital, this is perhaps number one. You can go to the hospital and they can scan these forms and put them in a file for you so that they can be electronically accessed. If you were to go to the hospital, it'll pop right up for them. And also you want to make sure that you're giving copies to your physician. Finally, for your durable power of attorney for healthcare, that person that you name to make decisions on your behalf, you obviously want to make sure that that person has a copy of all of your documents. Before I talk about this big red thing in the corner, I also want to make sure to remind you that anytime you update any of these documents, you want to make sure that these individuals have updated copies. So when you give copies to your kids, your parents, your friends, your doctor, your hospital, keep a list of that so that you know who will need to get an updated copy. You'll also want to keep in mind if an individual passes away that has your copy, or if your doctor's office closes or something like that, you're going to want to make sure that additional people or an additional person or your new doctor, whatever the circumstance is, has those documents as well. I've seen situations before where they gave a copy to a sister and then the sister passed away and then nobody else had the documents. So you want to make sure that everyone has them and make sure that you're updating them regularly and making sure that you're updating the list of who has your documents regularly. The last thing that I will address here is this safety deposit box on the right-hand side. Many people, for many years, relied on safety deposit boxes for important documents. The important thing to know about safety deposit boxes is if you put your documents in there, nobody's going to be able to access them. And they are definitely not going to be able to access them if they do have permission and a key after hours or on the weekend or things like that. They're not going to be able to access them quickly and efficiently if you're in a healthcare emergency. And health emergencies typically happen quickly and unexpectedly, so we're not going to have time or want to be going to the bank to access that safety deposit box. So do not put those documents in there. Those are not accessible, and we want to make sure that they're accessible and can be retrieved easily and quickly should you need them. The last thing that I will do is if you have any questions that we don't address in the chat, in the Q&A portion of today, you can always email me. It is my name, Erin Yelland, at ksu.edu, and I'm always happy to take questions from our local community members. Also, if you currently live in Lawrence, in that area, you can contact your local K-State Research and Extension office there in your county. If you don't live in Lawrence, you live outside of that county, you can contact your local K-State Research and Extension office. So simply Google K-State Research and Extension with the name of your county and it'll pop up. Those individuals often have many answers to all of your questions and can connect you with me as well. So that is all the information that I have. And I will stop sharing my screen and get back to all of our faces here.
All right, thank you so much, Erin. We've got some questions going on. I just want to say that we're going to switch to Webb's presentation, and then we'll kind of get all the questions going, because I have a feeling there'll be some overlap and some things that both of you can speak to. So thank you again very, very much. And Webb, it is all you.
For my part of the presentation, I'm going to emphasize three things. So first, make sure you're hearing me here, Kate. Am I coming through?
You're good.
Okay, good. All right. My program will emphasize three things that I think all of us should do every year, regardless of where we are in our estate planning program, what we've done, what our age is. We should every year regularly be doing three things. Number one, we should be reviewing our powers of attorney. This segues somewhat to what Erin was just discussing. She was talking about the durable healthcare power of attorney. But in addition to that power of attorney, you should also have a general durable power of attorney that I describe as being more in the nature of a financial power of attorney. Now, oftentimes we pick different people to serve as our agent under the general durable power of attorney than we would on the healthcare power. Erin mentioned selecting the child who is the nurse or other medical professional to serve as healthcare power of attorney. Similarly, you should think of the characteristics and qualifications of your children in selecting someone to act as your financial power of attorney. May be the same person, may not be. And this may be something that changes over time. So you should start with every year review who you're naming as your agents under all of your powers of attorney. The second thing that you should really be doing every year is making or reviewing a good comprehensive list of all of your assets. Now, I don't mean to count the silverware, but rather I mean to make sure that you've identified all of your bank accounts, all of your brokerage accounts. Some of us still have individual stocks and bonds that we aren't holding through a brokerage account. We have real estate. We may have partial interest in real estate. We may have family real estate in which various family members, brothers, siblings, and the like also own an interest. But make a good comprehensive list of everything that you have that is of significant value. Now, when you're making that list, I'm not so much concerned with what the precise value of those assets are, but it is appropriate to run a total of all of that so that you know the extent of the assets that you're dealing with. But I am more concerned with having you review how those assets are titled. By that, I mean they may be in your sole name, they may be in joint name. Joint tenancy means that upon your death, automatically and by operation of law, the property passes to the surviving joint tenant. You may hold things as tenants in common. That's oftentimes the case if you've inherited property from your parents and you and your siblings own that property. You may there own it as tenants in common, which means that in the event of the death of any one of those tenants, it passes down to their particular beneficiaries. If you own it just in your own name, then you may be able to attach a beneficiary designation to it. So on this list of property that we're coming up with, where we've identified everything that we've got, how it's titled, whose name it's in, then is there a beneficiary designation that goes along with that or that could go along with that? If it's your IRA or your 401k, then almost in all cases, there will be a named beneficiary. However, this may be an account that you opened before a significant change in your life. So if you have subsequently been married or divorced, these are things that we need to look at what the beneficiary designation is in this annual review and make sure that it is still appropriate. Bank accounts, you may have those in your own name, but under current law, you can have a pay on death beneficiary added to that account. That's much better than adding someone as a joint tenant. General wisdom is that you should not add anyone other than a spouse as joint tenant unless you really mean for them to take the property. But if you have someone added as a pay on death beneficiary, that beneficiary gets no interest in the property so long as you're alive, but automatically and by operation of law, upon your death, the pay on death beneficiary will take ownership of that property. That you can do as to bank accounts, brokerage accounts, real estate. You can make a transfer on death beneficiary designation so that upon your death, in the same way that the beneficiary takes no interest during your lifetime, but upon your death, the beneficiary would take title to that property automatically. Now, in going through that list of assets, we've talked about your bank accounts, your brokerage accounts, your real estate. Same can be done with regard to automobile titles. They can be put into joint tenancy, or they can have a transfer on death beneficiary designation added to them. So if you think of this list, most everything that any of us have that is of significant value can have some provision for a beneficiary designation or a passage of title to that asset upon your death without the need for going through any kind of probate process. So, number one, I've said review who you have as your agents on your powers of attorney. Number two, make a good asset list and identify title and beneficiary designation for each asset that you have on that list. Finally, third thing, review who your beneficiaries are. Your beneficiaries, ordinarily, a standard situation, will be children, spouse, then children, perhaps grandchildren, but identify and reflect on who you've named as beneficiaries. Now, once you think about those beneficiaries, they may have, as time passes, I see among my clients, I start with clients who have young children when they come in and we make their first wills or trusts. Time passes and those children grow up and they go on. They may still have documents that provide for their minor children when the children are no longer minor. As the children grow up, they may not only achieve adulthood, but they may have other issues in their life. And you should be alert to this. You should be alert to the fact that there may be a pending divorce. You should be alert to the fact that there could be business difficulties that your beneficiaries are getting into. They could have legal difficulties. So I look at your beneficiaries, think about who they are, think about where their life is at this point, and whether there is any need for you to be making some change with regard to the way your title passes to those beneficiaries. Now, if the beneficiaries are minors, we really can't use those devices, the beneficiary designations that I talked about in my list of assets, because minors are at a legal disadvantage with respect to owning title to property outright and in their own name. So we may need to do something different with them. As they grow up, similarly, we may be able to get rid of complicating factors or simplify your arrangements. So with this list of 3 things you're going to do every year, you're going to review who you have as your agents, you're going to review your list of assets, and you're going to review where your family stands, what the condition of your beneficiaries is at the present time, and whether it has changed. Now, if you do all of that, your estate planning from that point will be very situational. It will depend on your particular circumstances. But if you already have in mind the identification of your agents, also we would call them your fiduciaries, your assets, and your beneficiaries, then situationally, the estate plan that you need to have with respect to those people may become very obvious. If you have, for example, if you have the typical family married with young children, that is probably the situation where there is the most need for you to do estate planning. It's because of the presence of the minor children. For the minor children, you should be thinking, in the event something happens to you and your spouse, who would you want to see nominated as their guardian? And typically, the identification of a guardian would be done through having your will done and naming a guardian in there. If there are minor children and both you and your spouse are deceased, then you need a trust to provide for those minor children, at least until they attain an age of majority. And if you're going to have a trust, then you need to identify a fiduciary who will serve as trustee of that trust. Quite often, that fiduciary would be the same person as you were naming as your agent under a general durable power of attorney. So situationally, you're taking, if you've got a young family with minor children, you need to have identified who you want to be fiduciaries. If a need arises for them to step in, you need to identify the assets and figure out how they're to be held and administered for the minor children until they achieve their majority. And you need to think about the beneficiaries and whether they have any other special needs beyond just the age of minority. Now, situationally, we talked about there a married young children. If we have married with adult children, the estate planning actually becomes a whole lot simpler. Married with adult children, you and your spouse may have everything in joint tenancy, so that anything happens to either one of you, all of your assets pass automatically and by operation of law to the surviving spouse. So the spouse would tip joint tenant spouse, primary beneficiary on your IRA, your 401k, pay on death, as to any family, any bank accounts you have if it's not in joint tenancy. And then upon the death of you and your spouse, if the children are adult and do not have any other special circumstances, then you can simply arrange for the children to be named as the secondary beneficiary by way of POD or TOD beneficiary designations or designations under your IRAs. So there, as to that situational circumstance, married adult children, you really probably can have everything set up so that on the death of one of you, the surviving spouse takes everything without any need for a probate proceeding. And then upon the death of both of you, you can have everything set up so that it goes automatically to the children, again, without need for any type of probate proceeding. Oftentimes in the past, with this situation of married with adult children, we were, in years past, oftentimes building in trust arrangements to that. Many of those trust arrangements are no longer really necessary because trusts serve to do only really two things: avoid probate. You may be able to avoid probate by having beneficiary designations properly in place. And the trusts also served to assist in minimizing estate tax exposure. And in the present environment, estate tax exposure for most of us is really not a concern, since the per person estate tax exemption under present law is in excess of $11 million. Now, the thing that you have to keep in mind with respect to all of that, as with everything here, is that it's subject to change, and we are in a political environment where we are very much subject to change. Right, back to my situational review of all of this. I've talked about married with young kids and how they really need to do some serious estate planning. Married with adult kids, if the assets permit and the beneficiaries are all adult and mature and financially responsible, then it's a pretty simple situation. We could have single people who no longer have children. They are an ideal. If you are single and without children, then you should really be thinking, number one, you still need to have the fiduciaries. You need to have the agent appointed under your general durable power of attorney, your healthcare power of attorney, and you need to think about who your beneficiaries are. If you are single and without children or grandchildren, then you probably at least should be giving thought to whether you want to have some type of charity beneficiary designation built into your estate plan. And in the event that you do, then I know that the library will have considerable resources to assist you with some planning in that regard. But so I've situationally now just run through what would typically be, what would typically account for the situation of most people. Married young kids, married adult kids, single with no kids, and the estate planning in all of those cases can really fairly simply be done without need to have any recourse to a probate proceeding. Should people in those situations still have a will? And the answer is absolutely yes. Now, at that point, I need to emphasize, if you have a will takes effect only through the probate process. For a will to have any effect upon your death, it has to be admitted to probate by the probate court in the county of your residence at the time of your death. So a will is something that is going to be through the probate process. If you've correctly identified all of your assets and made beneficiary designations, then there may well be nothing left to pass under the will. And in that event, upon your death, what we would simply do is file the will with the probate court simply to preserve it and take no other action. But the will is a safety net to catch any asset that you might not have made other provision for during your lifetime. So it is something that we should all have, but recognize we may not need it. Similarly, or perhaps kind of conversely, recognize that if you have a will and you write in some special provisions about wanting to make provision for some other person, or wanting to make unequal provision among the children, or wanting to make a specific gift to some child or grandchild, keep in mind that if there is no asset left to go through the probate process, then the provision of the will naming that special gift or special beneficiary will not be able to be completed. So your will is a safety net. It takes effect only at your death and only if there is an asset that was in the sole name of the decedent. So everybody should have a will in all of these incidences. There is a way to complicate one's life if if there is unfortunately cause for a second marriage, whether by way of death or divorce, and an individual has entered into a second marriage, then the estate planning process becomes much more complicated and much more attention needs to be paid to it, because there are different provisions that you have a second spouse still is entitled to a spousal share of your estate. Your children are the only ones that would still be your heirs. If you do not adopt a spouse's children and they are only stepchildren, then they are not your legal heirs. And you should think about the ramifications of all of that, because it may or may not be consistent with how you want to make provision for the entire composite family. So that by way of your basic estate planning. It can and should be, for many of us, fairly simple in this day and age, now that that we do not have low exposure, or I should say high exposure, to transfer taxes. Though I would again emphasize that as we go through really into the next calendar year and a new political environment, we know that there may well be legislative changes that will affect all of that. So generally, with regard to further financial and estate planning beyond identifying your basic assets, your fiduciaries, and your basic beneficiaries and their particular circumstances, I've emphasized that you should still have a will. Do you need to have a trust? From my perspective, most of us, if we do not have minor children, or if we do not have beneficiaries who have special needs, then in the present environment, you may not be in particular need of having a trust. Things that might change that would be if you own real estate located out of the state, so that you need to have a vehicle for taking title to out-of-state real estate, so that you're not exposed to the possibility of probate out of state. That might be an occasion for having a trust. Erin mentioned something that I always try to emphasize with my clients as to the storing of their documents. It is important that you let the family know where you have stored your documents. She mentioned safe deposit boxes, and as she emphasized, keep in mind that no one can get into that safe deposit box unless you put them on the card for that the signature card for that safe deposit box. So if you're going to have documents stored there, I emphasize that you need to probably have the agent under your general durable power of attorney be on the signature card for that and know all of the details for obtaining access to everything. This kind of raises the additional issue in connection with this of how much should you be sharing with your kids about your estate planning arrangements. And obviously your particular family circumstances will influence the exact answer that you give to that. But as a general proposition, I think generally speaking, more often than not, it is best to share your estate planning arrangements with the adult beneficiaries and other family members, if there are other family members other than children that you have involved to act in a fiduciary role with respect to the administration of your estate. In sharing those documents, again, as Erin was emphasizing, we can make now electronic copies of all of these. And I find now that when clients leave here, we generally will have completed an electronic file of all of that so that I can transmit to them electronic copies of all of their relevant documents, including the will, the powers of attorney, beneficiary forms, beneficiary designation forms. It's important that all of those documents be a part of your composite estate planning file that you assemble during your lifetime. And tying that in kind of with where I began, that every year you should be reviewing this, and all of those documents you should be assembling along with your annual review of your assets and the titling of things. And as you look down the list of those assets, and if you see you had a beneficiary designation, it is best that you have a copy of the actual beneficiary designation included there in your file with that document. If it's joint tenancy to real estate, it's best that you have a copy of the real estate deed that's in there. So all of those documents that you've been collecting should kind of tie back into the file that you have with your annual review, where you're bringing it together with reviewing on a regular basis how you're doing, how your family's doing, how your assets are doing, because the one thing that we know is everything changes. So with that, Kate, perhaps I should release it to you and questions.
All right. Thank you so much, Webb. That was wonderful. Let's see. We've got some questions here, and Erin wants to pop back in. So first of all, thank you so very much. And I did want to reemphasize that we will be sharing out, I put a link to a document that Erin mentioned in the chat, and Webb has a handout that has further information and kind of puts all of this information in one place for you, and we'll be able to share that out on the library website and in our newsletter and things like that. So we will get all that to you. If you have questions, we've got a few to start. You can put it in the Q&A, and you're able to also ask anonymously if you'd like. We do have one. Our first question is from an anonymous attendee. And I believe, Erin, this would be probably for you, says that their mother is close to 91, very active and alert, though physically has arthritis, and so wouldn't call her frail or terminal, but shouldn't she have a DNR in your opinion?
I think that's certainly a possibility. And if she is ready and willing to sign that document, there's really nothing to stop her. The important thing is just realizing the implication of signing that and what that truly means. And like I said, with my grandpa, who was 92, he had one that was signed, even though he wasn't particularly frail or didn't have a terminal condition, but he did get sick suddenly and died. So it was really good that he had that already in place. So if she's ready and willing to sign that, I think that's a good choice for her.
Thank you. And I would say for both of them, but I think this came in during Erin's, are the forms that you all talked about recognized in other states and countries as well?
Webb might be able to answer this from the more of the legal side, but from my understanding, it depends, and that most states might recognize it and accept it, but that some may not. So Webb, do you want to take that one?
Spoken like a true lawyer. Everybody says they want a lawyer with one hand. That doesn't say, well, on the one hand, but on the other hand. It does depend. General proposition within the states, I think generally speaking, durable powers of attorney for healthcare, I think, are pretty routinely accepted. I mean, I've had clients where literally we fax them or email them all over the country. I've had clients that had terminal illness in California, and we sent the documents out there. They'd signed them here, lived here, moved to California, and they were given effective. So among the 50 states, the healthcare power of attorney, I think, generally is respected. The financial power of attorney is much more difficult because, especially as you go out of state and to big banks, they oftentimes have their own requirements. And you may find reluctance to have powers of attorney, general durable powers of attorney, accepted by banking and large brokering brokerage institutions in other states. So if you've got specific places that you're concerned with that you know of, you probably ought to have them reviewed if you're going out and dealing with other institutions.
Thank you. Okay. So it depends. That's good.
Right. That's a legal answer.
Yeah. It really does, though. Everything is very complicated. So someone asked during one of your presentation, what about life insurance policies? How are those, I guess, carried out, or what's the process there?
Beneficiary designation. So if you know your beneficiaries and they're adults and they're financially mature, as I always emphasize, then the insurance policy can be made payable to those one or more adult beneficiaries, competent adult beneficiaries. If it is something that you want to have the insurance policy be held for the benefit of your second spouse and then go to your children, then you're going to need to make the beneficiary, you're going to need to have a trust set up to pay the policy into. If the children are minors and you don't have a spouse that's going to take it, again, you're going to need a trust. So it's going to depend upon who you want to get the proceeds of that policy. Once you know who your beneficiary is and what their legal circumstances are, then you pretty much know who you want to make your beneficiary.
Erin, how does one revoke a DNR? If someone here who would like to revoke one?
From my understanding, that's a pretty simple process, such as that you could write over the document and say revoked, or destroy the document in some way, make sure that that's updated. Webb, do you have a more specific answer?
I don't. No, I think written revocation, writing on it, revoked. The problem would come that I think would be respected. The issue might be if you've given a copy of that to someone who still has the copy and they don't know of the revocation. And so you were the one you pointed out, Erin, to be very careful and make a list of everyone you give the document to. And that's a place where you would need your list.
And as a follow-up, I think, and sorry, Erin, if you did answer this, but I had heard at one point that if you kind of put your DNR, like there's like emergency responders, they would check like on your fridge or something like that. Is that still the case?
So there have been some initiatives across the state to make medical information available to emergency responders should you need to call them. So a couple of years ago, it was through the Kansas Department of Aging and Disability Services, I believe, started an initiative called Operation Red File, which was exactly what it sounds like. They would distribute a magnetic red big file folder that you could put up on your refrigerator that had your necessary documents, your medication list, your emergency contacts, all of those things. There's also other programs such as Vial of Life where you would keep those documents available. So there's several different programs that have been implemented across the state and even more that have been implemented across the country. But something simple to do if you don't have these programs in your area or if you're unaware of them is to make your own. You can get a folder and make sure that it is accessible and that you can see it on the refrigerator, things like that. So you can do your own. It doesn't have to be through one of these programs.
And then the responders, that's where they would check. They kind of...
Yeah, so with these programs that were implemented in these counties, they did training with first responders, both police and EMS, fire as well. So whoever's going to respond, that they would know to look on the refrigerator. So they may already have that in mind. Oftentimes first responders, if you're not at home, will look in a wallet, for example. So having a wallet card that says that you have these documents and who to contact can be a good idea. They might all look in glove box as well. So having those accessible and where first responders might look is important. Something else to think about is you could contact your local police department or fire department and ask them and say, should I be putting these documents in a specific place? Are you guys trained to look for them in a specific place?
Great, that makes sense. So we've got a question, how, and I'm assuming this is for both kinds of documents, but how do you make sure the most recent documents are known or shared? I guess, do you have advice on kind of keeping everybody up to speed on I guess, changes and things like that?
Yeah, I think you, if you're sharing information regularly, then I think it takes care of itself. If you're not, or if there's some change that you've been loath to put out, you've got Erin's advice to keep track of who you've given documents to is right on point. You're going to need to recover it. But you know, by and large, in my practice, it hasn't been that much of a problem to identify the most recent one. I suppose somewhat depends on your family circumstances too. If the family changes through some adverse happening, you can see where you might need to be more careful about that.
Yeah, and so also if you have something filed at the hospital, like a DNR or any of these the healthcare forms, you basically would just kind of let them know that they've been updated, that sort of thing. Good.
Yes.
All right. Okay. Okay, and so also if anybody is watching this, we're gearing this to all ages, and if someone is let's say single and without dependents, what's the default person, I guess, that makes the decisions as far as healthcare? If you have beneficiaries and everything set up financially, then who kind of makes those decisions if you don't have those dependents?
Are you asking on the healthcare side?
Yeah, healthcare side.
Yeah, I'll let Erin go first on that then.
I will let you take it to make sure that my understanding is correct. So.
All right. Well, my understanding is that if you are a single adult and you have not named a person to act as your agent, then there is nobody there. And so emergency care services will be provided. But if it becomes something that requires any kind of long-term treatment, someone's probably going to have to be appointed as a legal guardian. And that's exactly the reason why you need to have these documents that you and I are both talking about. It is vitally important that almost everyone have powers of attorney, durable health care and general durable powers of attorney. Because if you don't have that, there's really no one, there's not a simple default rule as I understand it. It is that you look to the court using the probate process, and unfortunately that oftentimes involves attorneys and expense.
And I agree with what Webb has said, and it's one of those answers again where it's complicated. My mom works in healthcare and she's in administration at a hospital, and they have seen numerous circumstances where someone will come in without a durable power of attorney for healthcare, and different doctors will handle it in different ways. And so it's not always guaranteed to go the way that a person might want. And as well, you know, if we have to go through the processes that Webb was describing, then that takes a lot of time. And if you're in an emergent healthcare situation, that's not what you want. So the most important thing to keep in mind is getting those documents completed.
And I think especially we've kind of framed this as in the time of COVID, you know, everybody obviously at all times should be looking at these documents, but that's especially important now, kind of during a pandemic, unfortunately. Okay, so I have a question here from the audience. Okay, so they say, I wish to have my family handle my funeral arrangements and bury me on private property. If this is stated in my directive, will a hospital or hospice release my body to my family, or would I need other legal documents in place?
You know, I'm not sure that I know the answer to that one. I've never had that question presented, never had to really look into it. My expectation is that I think a mortuary probably is not going to be releasing a body without some understanding of what disposition is to be made of it. So if that's what you want, that definitely is something that requires your pre-planning and making sure that you've got arrangements in place to allow it to happen. So I don't think that would be easily accomplished without that. That's just my opinion.
What kind of documents then do you fill out, or is that part of just a larger will, I guess, or?
Yeah, I would think I'd probably start with the mortuary, and you can make pre-arrangements at people of a certain age do, and when they say it becomes more relevant, somewhere I hope north of my age, but I haven't done that yet. But if it's on your mind, then I think that's something that you need to get some advice about, and I think we readily could probably find an answer to that. You might pique my curiosity.
Well, we have a follow-up from a different person who says, since the mortuary will release ashes to a family member, they could be spread on private property, then I guess that would be
they do that
an option. Mm-hmm.
And you know, I thought there was a rule on where you could dispose of those ashes, and there really isn't. That is pretty much unregulated. The property owner may have some qualms about your dispositing ashes, but otherwise, I don't think it's much regulated.
Fascinating. Well, waiting for a couple more questions to come in. Was there anything else that you all were interested in sharing, kind of anything that popped up as one or the other was talking, or any other things that you want to make sure people focus on?
I did answer a question in the Q&A, and I didn't realize that it would go away once I answered it. But someone had asked if copies were okay, and that is 100% accepted. If so, they don't all have to be original documents when you're handing those out to friends and family members and things like that.
We've got some word from Jill from Visiting Nurses saying that their hospice director said that a funeral home must be involved in a release of the body. So hopefully that further answers kind of that person's question. But it does, these really point out how much work goes into this, and how many people you have to kind of think about contacting, and how complicated the arrangements might be if you're not kind of in the traditional route of dying, I guess. Okay, let's see. Well, if we don't have any other questions, then I think we can wrap it up early. I wanted to thank everybody for coming in. Let's see. Sorry. Okay, got a comment in here that okay, so it is legal to bury a family member in the state of Kansas, according to this person. So is it possible to make changes to an existing directive, or how do you go about doing that? I think we kind of answered that in the presentation, but what's the kind of, in case they were, came in a little bit later, what's the process for changing an existing directive? Erin, do you?
So for the healthcare directive, basically the process is completing a new document and getting that signed and notarized or witnessed again, and then making sure that everyone who has your documents has an updated copy. So it's relatively a simple process, and then getting those old documents and destroying them or writing on them, you know, revoked, updated copy, something like that would be useful, but I would really recommend destroying them and replacing them with those updated copies.
Wonderful. All right. Well, thank you so much. Again, this has been recorded, so we will send out this recording for anybody who was not able to attend. We've put in the chat links to the documents that were kind of alluded to in the presentations, and we can share those out as well. If you have further questions, you are also welcome to contact the library, and we can do our best to research the answers for you or connect you to experts. Other than that, though, I hope you all have a wonderful day. Thank you again so very much for coming in and for presenting and answering all of our questions.
Thank you.
Thank you.